weeks now, the Nigerian media have been awash with news of a legal battle between the founder of Afe Babalola University, Afe Babalola, senior advocate of Nigeria, and a human rights lawyer and activist, Dele Farotimi. The matter is still in court. In POF television studio, we have the privilege to speak to the head of the legal team of Afe Babalola over this prosecution. The head of the legal team is a former NBA chairman in Ekiti and former Attorney General and Commissioner of Justice in Ekiti State. Barrister Owoseni Ajayi, you're welcome to POF television studio.
It is a pleasure to be here.
A cross-section of the Nigerian public believes that Dele Farotimi is being persecuted rather than prosecuted. What do you say to that?
That may be due to misinformation and misleading publicity on this matter that is purely illegal issue. It's only because they have turned it into a political case and somehow a political prosecution. That is why we are responding to invitations like this. Ordinarily, we should not be seen as discussing a matter that is already before a court of law. That may be seen as being prejudicial to whatever it is going to happen in the courtroom. In as much as possible that under the principle of law, of all the interim pattern, give the other side fair hearing before you judge. Dele Farotimi and his sympathizers has gone to the media to misinform the public about what is the actual reason why he is being prosecuted. We have a duty to clear that to the public. And may I go straight away to that reason why Dele Farotimi is being prosecuted. He published a book on justice in Nigeria. Ordinarily, there is nothing wrong in anybody putting his views into writing. But in this instance, he went ahead and published libelous and defamatory prints concerning the personality of Afe Babalola and other lawyers in Manuel chambers. That is the chamber founded by Afe Babalola. And in that book too, he scandalized all the stratum of the judiciary in Nigeria. He specifically published in his book that Afe Babalola corrupted, he used that particular word, corrupted the judiciary, both at the High Court in Lagos and also at the Supreme Court. And there are so many other things in that book. It was from the foreword to the book to the end. It was falsehood published against Afe Babalola and his chamber. And so many other prominent Nigerians, including Supreme Court justices, who are even retired now, who are not even in a position to defend themselves, who are even retired. Because the cross of his matter happened over 13 years ago, since 2013 to 2014. That was the cause of his agitation. What happened there? There was this land dispute between Badamasi, Eletu, and one other family in Lagos. The matter went through to the Supreme Court. It was at the Supreme Court where Afe Babalola was briefed by one of the parties. And he got judgment for them in the Supreme Court.
He wasn't handling the case from the beginning?
From the beginning. He was not the one that would handle it at the High Court and the Court of Appeal. It was at the Supreme Court that he was briefed. So, he won the matter at the Supreme Court. When the lead judgment was being read by my Lord, Honorable Justice Saka retired, instead of 524 hectares, that was the total area involved, he erroneously wrote 10. So when the judgment came out, and Chief Babalola discovered that there was an error, that is purely a clerical error. He now filed an application in the court under the relevant laws of the Supreme Court that please correct this error. The other parties were served with that application, not that it was done ex parte or solely done. And the error was obvious. It was thereafter corrected from 10 to 524 hectares.
Who did that favor in the suit?
Obviously, is the client to Afe Babalola.
Okay.
So, that was the end of that matter.
What was the role of Dele Farotimi in that case? Was he handling the case for the defendant, or
that is where I'm going? Okay. Dele Farotimi was not a party to the cases, either for the claimant or the defendant or for the appellant or respondent up to the Supreme Court. He was not also a counsel to any of the parties. Therefore, he could not have been properly served about what happened in the Supreme Court. He was definitely not in the knowledge. So, the stage he came in now, that land area is a Lekki area in Lagos.
He came in after the Supreme Court judgment.
After the Supreme Court judgment.
And the correction of the mistake.
After the correction of that judgment, of that error there. That was when he came in. One of the parties who had already got property on that land that area has now become a commercial area in Lagos, where we have Nikon, we have broad area, so many interested personalities now had property there. So after that judgment, all the interested parties started filing actions, one action or the other, to challenge the execution of that judgment. It was at that stage that Dele Farotimi came off on behalf of one of the tenants there. So nobody actually knew what happened to the case he filed, in which the chambers of Afe Babalola was not in any way involved. So that is why we were surprised that he is now accusing Afe Babalola of corrupting the Supreme Court justices to have a favorable judgment. So when somebody call you a name that you don't bear, when somebody libel you or defamed you, you have a legal right to protect. And it could be in two ways. You could sue in civil, claiming damages from the person who libeled or defamed you. You could also write a petition to the police for crime committed against you, because libel is double-faced. It's either in civil, that is tort, or in crime. So I opted to ask the police to please help me ask from this man what I have done to deserve this scary allegation against me, and to ask him to come and give evidence to prove that he corrupted the justices of the Supreme Court. That is within his legal right. And in following due process to achieve that, he wrote a letter to the police. Please, this man has done this to me in his book. Please help me investigate.
Why didn't Afe Babalola go through civil?
That is within its discretionary power. You know, I've said,
Yes.
you can opt for civil to claim damages. You can opt to have him tried in crime. And Afe Babalola said that I don't need this money. How much can he pay me? How much can he pay me if I'm to sue him, say, for 100 billion? Can he pay me? Do I need this money? But he took that step to see whether he could see reason and possibly apologize. Probably he has not seen the error he has committed. If the police invite him now, if he has evidence to prove it, he prove it to the police. Then Chief Babalola become liable. And if he discover that he have erred, a reasonable person at that stage, we apologize.
Some people believe that he shouldn't have been arrested and brought down to Ekiti.
No, that is the procedure. When somebody accuses anybody of committing a crime, the police has several ways of inviting that person. If they have his phone number, they can call his phone number. Please come to so police station. We have allegations against you there. Come and see us. If he refuses to come, as it happens in this case, he was invited, he didn't come.
From who invited him?
The police.
In Lagos?
In Ekiti here. They invited him. He didn't come. They now went to the Chief Magistrate Court to obtain a warrant of arrest. That is the next procedure. So that he won't say his right, his human rights have been impeded upon. The police could swoop on him and get him arrested. But they didn't do that. They went for a warrant of arrest. And that warrant of arrest was taken to Lagos and shown to him. He was not handcuffed, he was not rough-handled and brought to Ekiti. Let me tell you, when somebody commits an alleged crime, he could be arrested anywhere in the world and brought to the C2, that is where the offense was committed, and there with that allegation. A fresh example is Nnamdi Kanu was arrested in Kenya. He's been tried in Nigeria now. So anybody could be arrested anywhere. The fact that he was in Lagos doesn't mean he could not be arrested in Lagos and brought to Ekiti, because libel is worldwide. Anywhere the book is read, anywhere the book is published to, then the cost in those areas could have jurisdiction. Chief Afe Babalola is in Ekiti. We read the book. Those of us that are close to Chief Babalola and several other people read the book in Ekiti. Therefore, the Ekiti police could arrest him anywhere in this country.
Some critics are in doubt that the Ekiti State Police Command ever invited him before the arrest.
He was really invited because there is no reason why they know he's a public figure. He was really invited, but he declined that. So a warrant of arrest was obtained against him, and that was shown to him in Lagos by the security operative, and he was brought down to Ekiti. That is procedural. That is procedural in law. There is no infringement. That process did not infringe his fundamental right in any form.
Farotimi had a media parley. He granted a media interview before his arrest, speaking about the intending arrest, and that he was aware that there was a fraudulent court judgment against him, whereas he never appeared anywhere, he was never invited. Can you throw light on this?
No. Warrant of arrest is not a judgment of court. Warrant of arrest is a legal permission to get anybody arrested without his right being infringed upon. If he has not been invited, that is even an evidence that is already aware. If he's not invited, where the need for the press conference? So if he's aware that he has reason to face the police, instead of going to address the press, why not come and answer the police call? And has to wait until warrant of arrest was shown to him. He was being crafty. As far as I'm concerned, he was unnecessarily being crafty.
Before his second appearance at the magistrate court, there was another suit in the High Court in Ekiti. Who instigated that? Who instituted that?
Yes, it is the same police. You know, it is the police. When you write a petition like Afe Babalola wrote to the police will read it. Several petitions. But when they read it, they will invite the suspect. When the suspect gives his own statement, they will look at the two. This is the petition, this is the response. If a prima facie case is established, then they charge the person to court. If there is no prima facie case established, they drop the charge, they drop the petition against the suspect. In this instance, after the police investigation, after seeing the response of Farotimi, saying that he stands by everything in that publication, the police believe that a prima facie case, the meaning of a prima facie case is that there is a likelihood of offense committed in this matter. It was thereafter charged to court. That is procedural. Then thereafter, there were some other publications by him, like the one you are referring to, in
the media.
In the media, where he was repeating the same libelous publications. Apart from the one written down by him in a book, he went ahead to social media, circulated everywhere. So that is the cross of the one in the Federal Court.
In the High Court, he was granted bail.
In the Federal Court?
Yes. Why was the bail not followed up at the Magistrate Court? Everybody expected that the Magistrate Court, being a lower court, was going to follow what the High Court did.
No, they are separate courts. And the offenses the two of them are trying are different. They are not the same. Otherwise, they would have raised, they were brought up the issue of a double trial. The case in the Federal Court is completely different from the one in the Magistrate Court. And apart from that, bail is a discretionary power of the sitting judge. The Federal Court, probably after seeing the charges before him, believed that he could grant the bail immediately. But at the Magistrate Court, the magistrate discovered that there was a need for them to file a formal application for him to be able to see the facts of the case clearly before he takes a decision on it. And the bail application was argued about 2 days ago with a very lengthy submission by the prosecution counsel and the defendant counsel. It was a very lengthy argument. There was no how he could deliver a bench ruling on that sensitive submission. So it was within his power to say, okay, I'm not denying bail, let me go through this your argument. Then I deliver my judgment on December 20. There is nothing unusual. It is what happens in every court. Let me cite an example recently. There was a bail application argued for Yaya Bello. That was also in the Federal Court, Abuja. They could not deliver ruling immediately. Then they asked them to come back in another day for the ruling. It happens every day in every court. So that of Dele Farotimi does not take a different method.
The premise for bringing Dele Farotimi to Ekiti State was the criminal libel code that was understood to be in Ekiti.
Yes.
At the moment, it's being reported that there is no such provision within Ekiti State laws. So what happens to the premise for trying him in Ekiti State?
That is the subject for argument in court. That is the argument of Dele Farotimi's group. That is the argument. Our argument is that he could properly be tried in Ekiti. It is if they are not satisfied with that, it is the court that will rule on that. Because all these things are social media hype. without really going into the rudiment of law surrounding it. But let me clear something straight away, that we have federal law that is for every citizen of Nigeria. The criminal code is a federal law for the southern states. The penal code is also a federal law for the northern states. Anybody could be tried in all the states in the southern part of the country under the criminal code.
We understand it doesn't exist in Lagos. We understand it doesn't exist in Lagos.
As long as it depends on the case, as long as it is the federal establishment, like the police, that is going to handle the matter. What I'm saying is that in Ekiti or Lagos State, the Ministry of Justice there, that is in charge of criminal matters, cannot try libel under Lagos State law. But if it is the police, that is a federal agency, if they are being tried under the criminal code, they have jurisdiction to do it. So as I've said, these are arguments for the court to decide. That is our position. And we are right on that. But it is the court that will finally decide that.
Is there a possibility that Dele Farotimi also sues Afe Babalola if he is granted bail?
How can I speak for that? Am I his lawyer? I cannot, and I'm not a wizard to be able to determine what is in his mind. So he's free to do whatever he likes now.
It is understood that there are efforts to resolve this crisis out of court. Can you speak on that?
What I can say is that this matter has become a social matter. Nigerians from different devices are interested in the matter. To this effect, Dr. Peter Obi, the party under which Peter Obi considered as gubernatorial candidate, and Dele Farotimi is also a member of that party, where he discovered these problems, came to Ekiti State to appeal to Chief Afe Babalola to overlook the matter. And what Chief Afe Babalola told Peter Obi is that, was that I am a father of the nation, and God has sent me to develop people, not to destroy. That is stand by that principle of God. But that does not go to the extent of somebody destroying my hand image. He told Peter Obi, have you ever seen this person you have come to solicit on his behalf to see his position on this matter? Go and see him, whether he has actually given you a mandate to discuss peace with me. So, and what happened at the prison is another issue entirely. But Peter Obi had to go back. Disappointed. So, several other people are interested in that. But if the two objects cannot have a meeting point, if the two objects, that is Afe Babalola, and cannot have a meeting point, then the matter will continue in court.
What do you think about the personality, the mien of Dele Farotimi, his publication, his position as a lawyer, and this issue? What is your thought about him, and as a human rights activist?
I would just say human rights activism does not extend to destroy other people's image. That is how I can just summarize that. That you are a human rights activist does not go to the extent of publishing offensive words against another fellow person. Because the other person too has a right You say you are doing activism. You are publishing offensive words against somebody that have been called to bar before you were born. I don't think even if we drop law now, I don't think it's morally right. It may be subjective to his followers. And I want to repeat it again, that the immediate family of Dele Farotimi should go and talk to him.
Is he from Ekiti State?
I say his immediate, I don't know wherever they are. I want to appeal to his immediate family. Because when all things are down, the immediate family will be the people to bear the brunt. They should talk to him to come down on this matter. All this activism they are doing on the pages of newspaper and social media will not assist him. So, if he wants to face trial, if he has evidence that Arefa has corrupted the judiciary, he should go and do it in the court of law. All this grandstanding everywhere, demonstration everywhere, polluting the social media is not the issue.
What is Afe Babalola's condition to resolve this matter out of court?
That is what I'm saying. It's very simple. His condition is very simple. For him to apologize and retract those offensive words. That is all.
How does he retract?
We issue a statement of apology, retracting those offensive words that Chief Babalola corrupted the Supreme Court justice and the judiciary in its entirety, that he corrupted them, that he never meant that. It's as simple as that. So, because going through all this, this case is developing other legs now. There is a suit against him in Abuja by Kehinde Ogunwumeju and SCN, in which another has been granted against publication and selling of those books. The same similar order was granted in another case by Adeni Kwekun SCN in Ibadan High Court. And I learned this is being followed up with a petition to the Legal Partition Disciplinary Committee on how a lawyer can raise such a damaging publications against the title of the judiciary. He has to be very careful, because he's a lawyer. If he has been practicing for 25 years, he sweated to be admitted to the university to read law. He was in university for 5 years, in law school for 1 year. He wants to end up everything like this. I think they should talk to him. That is my personal view.
If this matter is resolved out of court, what happens to the publications that have gone international, global, and is even on Amazon, and we understand it's rising in terms of status?
That is the issue.
So what happens to that, even after he has apologized?
That is the issue. Or people are asking Chief Afe Babalola to drop this matter.
Yes. I'm
not in that school at all. That Chief Afe should go and drop these trials against him. The truth must be out. The court must take a decision on this matter. When the court take a decision on this matter, then so be it. That will have erased all other publications. If the court takes on behalf of Chief Afe Babalola on this matter, then it will have erased, because that will go into internet too. That will erase whatever damages this might have done to him.
But there are some who are of the view that there's a possibility that he actually has damaging evidence against Afe Babalola.
And that's why we are in court now. Let him bring it. We are not afraid of that now. If he has, let them bring them to court now. If Chief Afe Babalola is aware, he's an experienced person in life, well talented. If he knew he had done something that could indict him, you think he will go out to this late? So if he has evidence that he corrupted the Supreme Court, let him come and tender it in the court of law.
Barrister Owoseni Ajayi, we thank you for coming on to speak further on this legal battle between a senior advocate of Nigeria and founder of Afe Babalola University, and the human rights activist, Dele Farotimi. We look forward to hosting you again. But what do you see happening in the court, the third appearance of Dele Farotimi on the 20th of December?
I cannot predict that. The Nigerian that look into the argument, he said he's going to read them and deliver his ruling. He said that for or against. I cannot predict. I don't know what is in his mind. So the prosecutor said he should not be released on bail because he's socially dangerous. His team said it's a bailable offense, that they should release him. So it is the magistrate that will decide between the two. So I cannot say anything on that.
Barrister Owoseni Ajayi, thank you very much for coming.
It is a pleasure. It is a pleasure. I will be here to see you, my good friend.
People of the Fountain.